Welcome everyone to another exciting Zoom and Learn with Celebration magazine. Today we have our special guest, Brandon McGee with McGee Law Firm. Now to tell you a little bit about Brandon, Brandon is I apologize, guys. I messed up, but that's okay. Brandon is the co-owner of the McGee Law Firm. He is born and raised in Dallas, Texas, and he attended Texas Christian University, where he earned his bachelor's in 1998. He graduated from Emory University School of Law in 2001 and is a member of the State Bar of Texas, the National Academy of Elder Law Attorneys, and is the only DFW member of the prestigious American Academy of Estate Planning Attorneys. That is pretty darn impressive. So today, Brandon is going to be talking about how to avoid common mistakes that are made in estate planning. So, Brandon, go ahead and take it away.
Okay, thank you so much. Let's get things going here on our end with the slideshow. Okay, guys, so let's go ahead and get started. First off, thank all of you guys for joining us here today. I'm going to do my best to make this as interesting as possible, meaning I'm not just going to regurgitate a bunch of legal codes and laws to you. We're going to present some practical issues that we see happen to a lot of our clients that come in the door. And some of these situations, you guys may think, some of you may think, that's the boat I'm in right now. Others of these situations, you might think, well, I've got a pretty good grip on this. And as we go through this, keep in mind that we're going to be dealing with a lot of heavy topics. So, I just watched you guys interact and people greeting each other and, joking around and having a good time. And now I'm about to drop a bunch of heavy subject matter on you. But I want to remind you that the goal of having a good estate plan is not to sit around dwelling on things that may happen in the future that aren't so positive. The goal of it is just to prepare for the reality that some of these things are going to happen to you or going to happen in your family. And what I found is that my clients who really have their estate plan in order, they're the ones who can go on about their life and not think about this stuff and not worry about it because they feel confident that if something happens, they're prepared. It's the people who don't have the preparation done who generally kind of have it in the back of their mind, when you wake up first thing in the morning or you're going to bed at night and you think, oh gosh, what about this and what about that? We want to get rid of all that and just have everybody have a really good understanding by the end of this webinar as to the things that you should be doing and the things that you can do. So let's get started. First off, whenever I present live, which is what I'm accustomed to doing, is a live seminar. Of course, the COVID virus has changed a lot of things in society, including live presentations are out the window for the time being. So, but I normally will give hard copies of materials that reflect the subject matter that I'm talking about today. And so we want to offer to all of you guys, if any of you would like a copy of not this exact slideshow, but of the subject matter in general, the topics I'm covering, explanations, give us a call or send us an email. We're happy to get that to you. So I just had a really nice introduction, but here's a little recap. So I am a DFW native. Currently, I do live on the west side of the Metroplex, and I have an office in downtown Fort Worth, and I have an office in Southlake. However, I serve clients all over DFW and, in fact, all over Texas, particularly in the age we're in today with Zoom and FaceTime. We have a lot of good options out there besides meeting in person, but we are situated here in DFW. Also, everything that I'm going to tell you today will apply anywhere in the state of Texas for any Texas resident. Out of state, what I'm going to tell you may or may not apply. Each state has its own legal jurisdiction when it comes to estate planning, so keep that in mind. Our discussion will be for purposes of Texas residents. As mentioned, I'm a member of the American Academy of Estate Planning Attorneys, a wonderful organization founded in 1993 in San Diego, California. And we're highly vetted before we're let in. This is not an organization that just any attorney who wants to can join. And we have extensive continuing legal education. We have a network of great attorneys across the state and the country, and great research department. And it's just a phenomenal organization that I feel very fortunate to be a member of. National Academy of Elder Law Attorneys. Now, this is one that I will admit, all I had to do to join this organization was be an attorney and write a check every year for my fees. But nonetheless, it's also a great organization. It's a much larger organization, and they really keep us up to date on trends in elder law, and also provide a good network to other practitioners across the state and the country. And backing up real quick to the American Academy, whenever you are speaking to an American Academy attorney or hearing an American Academy attorney speak, such as myself, you know that this is our area of focus. So this is what I do. I practice estate planning and elder law. I do not practice other areas of the law. This is our very specific and purposeful focus. So it's what we do day in and day out. We have an A+ rating with the Better Business Bureau. Now, why am I an estate planning attorney? What's the reason for that? Because as an attorney, I'm sure you guys know, there's 1,000 other things that I could be doing, right? All sorts of areas of the law out there that you can practice in and focus on. Well, for me, when I got out of law school, many years ago, it seems now, I had no interest whatsoever in being an estate planning attorney. I'll just be honest with you. I wanted to be in the courtroom. I wanted to be a trial attorney. I wanted the excitement and the fireworks of that. And so I went in, and that's what I did. Especially for the first 10 years of my career, I had a heavy trial docket, litigation docket. However, I started getting, after about a decade of that, I started getting kind of burned out. It's a very stressful way to make a living, high stakes, high stress. I enjoyed it for a time, but then once I started my own family, which you'll see here on the right, married another attorney. She's a real estate attorney, my wife, Rita. We have twin sons, fraternal twins, Cole and Hunter, who are now 12. And I started getting kind of burned out, and I had a smaller part of my practice, which was estate planning, but it wasn't super developed. It wasn't something, I wasn't providing the kind of service that I provide now to clients. It was much more basic, but I really enjoyed it. Well, in the year 2012, my wife, Rita, at the age of 39, developed stage 3 breast cancer. At the time, I was running a law practice. She was running a law practice. Our twin sons were about to turn 4, and this was May of 2012. And for any of you who have been through this kind of diagnosis in your family, especially for somebody who is maybe a bit younger, but for anybody really, it's really, really shocking. It was really out of left field for us. It was the last thing in the world we were expecting. And so that diagnosis came in May of 2012. Rita started chemotherapy right away. And about 32 days later, my father, at the age of 64, in his backyard in Dallas, Texas, on July 1st of 2012, died of a sudden and completely unexpected heart attack. And it was the night before, he had been at the Rangers game with me and my sons. And it really was one of those here one moment, gone the next type events. Big shock to the system. So my family in that year, we had 2 very big shocks to the system back to back. And so I started doing a lot of thinking, a lot of soul searching about life in general. And I came out of that year 2012 deciding that I might as well get up every day and enjoy doing what I do, and be excited and passionate about what I do. So that's when I decided to convert my law practice exclusively to estate planning and elder law. And it's one of the best decisions I've ever made, and I've never looked back. Very, very happy to say my wife, Rita, in October of this year will be 8 years, no evidence of disease. So that's the best part of the story, is she's doing great. Okay, enough about me. Let's talk about the law, because that's why you guys are here. So we're going to go through 7 very common mistakes that I see a lot of people making. Now, most people aren't making all of these mistakes, although some are, but most people are making several of them, right? But as we go through these mistakes, kind of think about your own life, your own estate plan, the way you have things set up, and let's kind of think of, is this something a mistake that you are in the active process of making, or are you in good shape? But planning mistake number one is no nursing home protection. One of the big things we look at in estate planning is if you or if your spouse have to go into nursing care, which is becoming quite expensive, is there preparation to pay for that? Do we have some source other than your estate to pay for that? Or do you have enough money that's not a big deal? For most of us, it could be a big deal. 50% of Americans who reach the age of 65 will end up in a nursing home at some point. So it's one half of us. It means if you're married, the stats say there's a 100% chance one of you will end up in nursing care. 22 months is the average stay, okay? About $80,000 a year. I think this number is a little outdated, really. I think it's, from what I'm hearing lately, it's closer to $7,000 a month for skilled nursing care. There are some people that need 3, 4, 5 years of nursing care. So it can become a really big expense. Now, a lot of times I sit down with a family and I'll ask, if one of you passes, one of you has a medical episode next week and you have to go into care, how are you going to pay for that? And a lot of times I get a blank look. So let's take a look at the different ways there are to pay for long-term care and kind of see where you fit into this. Number one, use your own money. Now, if you've done no other planning whatsoever and this happens in your family, you are going to use your own money. There's just simply no other choice. You're going to start writing checks. You're going to, start losing money out of your savings account, out of your retirement, whatever it takes. The money is going to have to be paid to the nursing home. Way number two is to look at purchasing long-term care insurance. Now, long-term care insurance has come a long way since 30, 20 years ago. There's many different options. It's not just all the premium monthly payment option anymore. In fact, that's kind of going out the window. Lots of different ways the insurance companies can structure this. I'm not going to get into the details of that because it would get us way off track. Could be a topic for another day. But I encourage all of my clients to look into insurance because it will generally pay for home health, assisted living, memory care, or skilled nursing. And it's nice to have an insurance company on the hook to pay for that stuff, or at least part of it, right? However, there are some people that maybe like my wife, they've had a serious illness in the past that would prevent them from getting coverage, or maybe they're of an age where it's just not practical, or maybe it just doesn't fit into your budget. But I want everybody to look at that. I always recommend it. And if it works and there's a policy out there that you feel fits your needs, that's great. If not, we move on down the list. Next is to apply for limited Medicare benefits. Medicare is not going to pay for a prolonged long-term care stay, or maybe what we would call a permanent long-term care stay. Medicare will pay for a limited amount of time of rehab. For example, my mother-in-law about 2 years, a little longer than 2 years ago, she fell, she broke her hip, she had to have a hip replacement. And that's the kind of thing where Medicare would pay for her recovery time in the nursing home. I think she had to spend 4 or 5 weeks rehabbing in a nursing home, learning how to, walk again on the new hip. And Medicare will pay for something like that. It is not going to pay for the permanent stay. So let's say that somebody, again, this person, my parent, my spouse, they're going into a skilled nursing home, and that's where they're going to spend the remainder of their days. We would look at Medicaid, okay? Medicaid, we were about to go into some fairly substantial detail on. For now, I'll just leave it at, this is what is going to be used in the state of Texas for what would be considered fairly low income, low asset seniors to pay for their long-term nursing stay. However, keep in mind, there are things that we can do to qualify families that are not low income, that are not low asset. There are estate planning devices and documents that we can use in advanced planning to qualify families, even though they otherwise should not qualify. Last, certainly not least, veterans aid and attendance. First off, I want to thank any of you guys or ladies who are veterans, or if you have a spouse who is a veteran, thank you for your service. And second, I want to let you know that some veterans, definitely not all, have something available to them called Veterans Aid in Attendance. You need to check with the VA on that. I can kind of give people an idea of if they qualify, but I'm not the authoritative source. So if any of you guys are veterans or your spouse was, please go to the VA, see if you qualify. They need to be the one to tell you yes or no. And also it does extend to some spouses, not all. There's a lot of detailed and specific rules to determine that the VA is going to have to tell you. Keep in mind this though, just like with Medicaid, you can qualify for VA based on your service. You may have 6 Purple Hearts, but if you have too much money or you have too much income, just like with Medicaid, then you will be disqualified. It's for people who are considered to be more low income or low asset. However, just like with Medicaid, there are things that we can do to help families qualify who otherwise have too much money or too many assets. Okay, let's get into the meat of the matter with Medicaid. Let's say that you've kind of zeroed in on things and you feel that insurance is not for you. Maybe you're of an age or a health status where you're not going to get it, or just doesn't make sense financially. What is Medicaid all about? Well, it's a state-run program, but it's funded in part by federal dollars. The feds basically say to each state, you can opt into Medicaid if you want to. You don't have to. And if you do, you have to follow this certain criteria on who can qualify. But then we have this other area of criteria in which each state makes their own rules. So what is true in Texas may or may not be true in Oklahoma, Colorado, Florida, New York, California, you name it. So keep in mind, we're talking about Texas Medicaid today. So Medicaid is going to look at 3 main categories. And there are 3 prongs that you have to meet to be able to qualify. Prong number 1 is you have to have a medical need for round-the-clock medical care. So this isn't for somebody that just wants to go into a nursing home because you think it would be good for you. You need to have a doctor, a treating physician, write a report convincing Medicaid that you have an absolute 100% need for round-the-clock medical care. That's prong number 1. I can't help you with that. There's no attorney in town that can help you with that. That's between you and your doctor, and the doctor writing a strong report for you. Number 2 is going to be your asset limit. Your assets have to be under a certain limit, which we're going to look at those numbers here in a minute. If you have $1 more than that limit, you will be disqualified from Medicaid. However, there are things that we can do that we'll talk about to help families qualify, even though they have too many assets, too much money. Prong number 3 is income. Your monthly income has to be at a certain threshold or less. If you have $1 more, you will be disqualified. And trust me, $1 more, 37 cents more, they will disqualify you. Medicaid looks for any reason to do that, unfortunately. But so I told you about the first prong, the medical requirement. It's up to you and your doctor. Let's look at the second prong in assets. Does Medicaid count every asset that you have? Your car, your house, your bank accounts, your retirement accounts, stocks, bonds. Are they going to count every single thing when they calculate your total amount of your net worth? And the answer to that is, fortunately, is no, they will not. Medicaid has, let's imagine, 2 baskets. They have one basket over here, let's say on the left, and they're going to put your countable assets in that basket. So those are the assets that they will count. Then they'll have a basket over here on the right called non-countable that they will not count. Now, from a Medicaid standpoint, we like non-countable assets, right? In the real world, outside of Medicaid, we don't care. You know, we're just happy to have assets. But when it comes to Medicaid, in trying to qualify, we want as many of our assets in the non-countable basket as possible. So what are non-countable assets? Real critical issue right here. Number 1 is your homestead up to $595,000 in value. If your home is worth less than that, and I mean your equity in your home, you know, somebody might have $1 million house, but they've paid 1 mortgage payment and that's it. They don't have much equity. But if your equity is 595 or less, we put that in the non-countable basket. That's phenomenal for Texas residents. Not all states do that, but in Texas we do that. You don't have to sell your house to qualify for Medicaid. Now, if you are over, let's say you're over $25,000, Medicaid will just count the overage, not the entire amount of the house, okay? All other property is gonna be countable, but we'll get to that. Personal belongings within reason are non-countable. So I'm not talking about expansive gun collections, coin collections that are real expensive, lots of expensive jewelry, notable artwork, things like that. That will be counted. But if you have just kind of the general stuff that most of us have, nothing real fancy, nothing real out of the ordinary, that will not be counted. One vehicle titled in the name of the Medicaid recipient, as well as one other vehicle titled in the name of each family member residing in the house, is non-countable. Vehicles includes anything that's titled. So this can be a boat, it could be a motorcycle, an RV, in any titled vehicle in the state of Texas. An irrevocable prepaid funeral plan for you and your spouse is non-countable. Okay, so that's great for us. That means that you can have paid your burial plot, your funeral fees, your headstone for you and your spouse, and we're not going to count that. Equitable interest in life insurance up to $1,500. Okay, thanks a lot, Medicaid, not much money. Now this is an equitable interest in life insurance. We're not talking about a post-death payout. You can have a post-death payout of $3 million and you have absolutely no equitable interest in that while you're alive. That doesn't count. That would be non-countable. Now there are some annuities that are non-countable. However, the vast majority are countable. I don't want to talk for 30 minutes on this topic. You would get very bored and we'd get way off track. Just keep in mind this, when it comes to trying to qualify for Medicaid or looking to set up your estate for that, you absolutely need to work with a legal professional such as myself who is experienced in this specific area of the law to review all of this stuff, particularly when it comes to annuities. So that's something you would need a professional to look at who's experienced in this area to tell you if your annuity is non-countable or countable. But go ahead and assume your annuity is countable because chances are high it is. Now, what are countable assets? What's Medicaid going to count? Everything else, right? Any real estate that you own above and beyond your homestead, any extra vehicles in your household, you're going to have 401ks are countable, CDs, stocks, bonds, mutual funds, checking accounts, savings account. The only thing that is now non-countable as of a few months ago that for years and years and years was countable, and I actually need to update my slides to reflect this, but there are now in Texas, if you have an IRA and it is a retirement IRA that you pay taxes on as you withdraw, and you are over 72 or older, and you are taking your required minimum distributions, your RMDs, the way you're supposed to, that is now a non-countable asset in the state of Texas. And that's a big deal. That's going to help a lot of us out. Okay. But your other IRAs, your 401ks, everything else other than what you see on this list is countable. Now let's look at the asset and income caps. A lot of you have probably been wondering about that as soon as I started talking about Medicaid, and that's a fair thing to want to know. I'd want to know too if I were you. So if you're a single person, you can only have $2,000 or less in countable assets. You have $1 more, you're out. Medicaid is going to deny you, okay? So obviously that leaves people pretty much destitute for the most part. That leaves people not passing much on to their next generation, unfortunately. If you're a community spouse, meaning you're married, not that you used to be married, but that you're married right now as the applicant, if you can have up to $128,420 in countable assets, and that's it. So that leaves oftentimes the spouse in a bad position, particularly a couple years ago, I had a client, a really nice couple. The husband was 84, the wife was 72. She was in seemingly great shape. She had great genetics in her family for longevity. her husband was not doing very well. It seemed that probably in the next year or so, some different problems going on. He might need to go into care. She was absolutely scared to death of this situation because she planned to live another 20 years, right? And she didn't want to have to spend down to $128,000 of all of their countable assets until her husband could qualify. Because for them, and at that point in time, they would have been spending down almost all of his retirement, which she had planned to continue living off of. Now, if God forbid both spouses have to go into long-term care at the same time, they can have together $3,000 in countable assets. Now, let me tell you this. A lot of people say, well, what if I'm a recent remarriage? I got remarried 3 years ago and I brought $1 million into the marriage and my spouse brought $500 into the marriage. Certainly if my spouse has to go into care, they're not going to count the $1 million I brought into the marriage. And the answer is yes, they are. If you were married, Medicaid is going to count everything, even if you were married yesterday. So you got to keep that in mind if you're thinking about, getting married. It doesn't sound very romantic to be thinking about Medicaid, but it might be something you want to keep in mind. Okay, you are combining your assets, and you could lose some of your assets to a nursing home stay if your spouse has to go in. Income cap. So what's the amount of money that we can have monthly coming in? If you're a single person, it's $2,349 per month. You have $1 more, you're ejected, you're out. They're not going to accept you on the Medicaid. If you're a community spouse, it's $4,698 per month. You have $1 more, you're out, not getting on Medicaid. Now, is there something that we can do about this? What if you say, look, I've got $700,000 in countable assets, and I've got $7,000 a month coming in monthly income. Am I just in a bad position here? And the answer is no. On the asset side there that you see on the left-hand side of the screen, we can establish what is called an irrevocable Medicaid protection trust. You can put your assets into that trust, and 5 years later, there is a 5-year look back, okay? So you got to wait 5 years. This is not the last minute crowd. This is the plan ahead crowd. But 5 years later, Medicaid will not count those assets. Excuse me one second. So that's the solution to too many assets. That's the solution for the proactive family who's planning ahead, is an irrevocable Medicaid protection trust, so that Medicaid cannot count them as your assets 5 years later. What if you say, okay, we've got that under control, we feel good there. Now, what if I have too much income? I've got, $4,000 or $5,000 more income than what I'm supposed to. We can set up something called a Miller's Trust, reroute our clients' income into the Miller's Trust rather than hitting their personal bank account, and they will qualify. Now, there is no look back right now on a Miller's Trust. So this is something that we can wait till the last minute. It's one of the very few things I'll ever tell you that in estate planning, but Miller's Trust is something that we can hold off to the last minute. So those are the asset and income limits. And I just told you guys a solution to being too top heavy with assets and income, irrevocable Medicaid protection trust, and then a Miller's Trust. Pitfalls to avoid here. Some people, they set this stuff up and they think, well, I'm in the clear. We've got all this set up. If I have to go on Medicaid, we're going to save all this money. My family can inherit from me what I have, rather than paying my life savings and my hard-earned retirement dollars all to a nursing home. Pitfalls to avoid. And I'm actually going to start at the bottom with MERP, Medicaid Estate Recovery Program. Their job is, after a Medicaid recipient passes away, to go and collect every single dime they can from their estate. So it makes sense, right? The state of Texas wants to balance the ledger. They paid $150,000 out for your care. They want to go get $150,000 out of your estate to reimburse the state of Texas for that. However, if you set up your estate to avoid probate court, which next, here in a minute, we're going to go into a lot of detail about that. But if you set up your estate to avoid probate court, by and large, your estate can avoid having to pay MERP, meaning Medicaid can pay out $280,000 on your behalf and may not collect a dime when you pass if you set things up right, which means that $280,000 is going to go to your children or your grandkids, whoever you want it to go to. So keep that in mind. We need to set things up on the tail end, not just the front end, or else Medicaid gets the money in the end anyway. So it's very critical. Now, other things to look out for: the $15,000 annual gift tax exclusion. Some of you may be aware that the IRS has a rule right now that says that you can give $15,000 to as many people as you want in a calendar year, and as long as you don't go over $15,000 for any one person, nobody pays any taxes. However, if you go over $15,000, then you are going to pay, as the giver, you're going to pay a gift tax on the overage. A lot of people thinks that will apply to Medicaid, and they think, well, I'll just start giving $15,000 a year to everybody in my family, and that way, by the time I have to go into a nursing home potentially, I may not have much left. There's lots of problems with that, in my opinion, but one big problem is you're going to be paying out the wazoo on gift taxes. Okay. If you go over that. And then number two, Medicaid does not recognize that. Medicaid does not care about the IRS gift tax exclusion. If you start gifting to your family and you go to apply for Medicaid, you're going to be denied. They have a specific formula that they use to tell you how long you're denied for. What I can tell you is that the punishment is always worse than the crime, without going into all the details. But if I, gift $100,000 to one of my kids, and then I go apply for Medicaid in 2.5 years, I'm going to get denied, and I'm going to get told that you cannot apply for Medicaid until a certain time in the future. And that time in the future, by the time that time in the future comes around, I'll probably have spent double what I had gifted. So the punishment's worse than the crime. So if you're going to go a Medicaid route, please do not be deeding and gifting assets to other family members. Now, you can give generic birthday presents, Christmas presents, but we want to avoid giving away of assets. Be very problematic, and basically those family members will have to cough up the money to pay for your care if you're out of money. Otherwise, you've got big problems. Okay, let's kind of do a quick review here. Then we're going to move into some other topics and get off this topic. Putting everything in children's names as an option for long-term care planning. Horrible plan for a whole bunch of reasons, including the one that Medicaid will punish you, not let you on for months and months and years, and your kids will have to give back the money anyways. Number two, the irrevocable Medicaid planning trust, very effective frequently in limiting assets, making assets non-countable, but there is that 5-year look back. Income-only planning trust, which is similar to the Miller's Trust. That is something that we can use at the very last minute if we have too much income to qualify for Medicaid. Changing assets into non-countable assets. That's something that if Medicaid's a part of your plan, let's just start doing that now. Let's start taking money out of savings accounts and buying burial and funeral plots. Let's take money out of savings accounts, put it into updates, renovations of our homestead, those things that are protected. Long-term care insurance, something to look into, might work for you, might not, but look into it, please. Medicaid crisis planning. This is for the family that waits till the 11th hour. This is the family that has done absolutely no planning. The husband has a stroke, he's in the hospital, and the doctor's telling the wife and the kids, in 3 days, we're going to discharge him. He can't go home. He has mental disability now. He has physical disability. You're going to need to find a nursing home for him. And you're looking at cutting $7,500 checks a month. There are things that we can do at the very last minute as a elder law, estate planning law firm to help families salvage some of this money. Usually not all of it, very rarely all of it, but we can help in the 11th hour as well. So keep that in mind. But that's worst case scenario. You don't want to be in that position. Okay, let's move on from nursing home and how to pay, different ways to pay for that. And let's move into planning mistake number 2, which is going to be no protection to pass on hard-earned wealth without government or court control. So you recall me maybe talking about probate court and how if we can avoid probate court, Medicaid can't come after our assets. In general, even if you're never going to be on Medicaid, avoiding probate court, in my opinion, is a very worthwhile goal that I encourage all of my clients to pursue. There are 2 things in the state of Texas, 2 situations that can land you in probate court. Number 1 is guardianship, or what we call living probate, and that's where somebody loses their mental capacity. They don't pass away, but they lose their rational thought. It could be Alzheimer's, could be a stroke, could be a car accident with a head injury, a lot of different things it could be. But that lands us in probate court if we haven't set up our estate to avoid it. And also death probate, passing away. The probate court's job is to appoint somebody to be in charge of an estate and to tell that person in the way, shape, and form they're supposed to distribute that estate. Okay. Now, are there ways to completely avoid the court system in the state of Texas, the probate court system, whether somebody passes away, whether somebody becomes mentally incapacitated? And the answer is 100% absolutely yes. If you do things the right way, there's no reason that you or your family should ever have to go through the probate court system. Now, before I tell you how that is, let's talk about why do you want to avoid it? What's the big deal here? Well, number one is the expense. It is always cheaper to set up to avoid probate court than to go through probate court. That's number one. Paying some money on the front end to get things done the right way will save you money in the long run. We have attorney's fees, court fees, publication fees, potentially bond fees. Sometimes there's a third-party attorney that's appointed by the court. You have to pay him. Also, it can just be very stressful. It can be very time-consuming. You're dealing with a lot of legal and judicial red tape, a lot of hoops that you have to jump through. You got to go to court, in downtown Dallas, or if God forbid, that's a real zoo right now, downtown Fort Worth, Denton, McKinney, wherever you may be. But the point is that at some point you do have to make court appearances in these kind of cases. You have to hire an attorney, pay the attorney. Also, another thing that I should put up here is it can really avoid family feuds or family bloodbaths if you can avoid probate court. So when we go through the court system, oftentimes we're setting up for big family feuds over different topics. Okay. So those are some really good reasons to avoid probate. Another one is multiple probates. If you have real estate in states other than Texas, so here in North Texas, it is unbelievable how many people have moved in here the last 10, 20 years, right? Maybe a lot of you guys have come in the last 10 or 20 years from other parts of the country. And and a lot of my clients, not a lot, but some, let's say, will still own land where they're from. They may have the family farm in Nebraska, or they may still have a house in New Jersey, a home in Michigan, different things like that, condo in California. And a Texas probate court can only transfer interest in real estate or authorize that transfer if it's Texas property. So I had a client a few years back. His dad owned land in 3 different states. My client all he left behind was a last will and testament. My client had to go to 3 different states and hire an attorney to probate his father's will to get ownership of the land in 3 different states. I think he ended up spending $20,000 to $25,000, and it took him about a year to get done, and he had to travel to 3 different states. So just quickly before we get into the details, I'll kind of give you the highlight. What are the solutions to this? How do I avoid probate court in the instance of death probate? And the traditional answer, the most common answer, is to have what's called a living revocable trust. To have a living revocable trust, put your assets in that trust, you can completely avoid the court system. What's the way to avoid having to go to court in the possibility of mental incapacity? And the answer is to have powers of attorney. And we'll talk a little bit more about that here now. So planning mistake number 3, no documents for passing down assets after death or planning for mental incapacity. So let me tell you this real quick. We'll start with mental incapacity. If I get out here on I-35 or I-30 or 121 later today, and I end up in a bad traffic accident, and let's say I'm in a coma, I have a head injury, I'm in a coma, my wife goes to the hospital. If she has a set of documents called powers of attorney, of which our office provides 7 to our clients, she should be able to make all manners of medical decision. She can get my medical records. She can go to another hospital, get a second opinion. If she needs to put her house up for sale, she can do that. If she needs to access my business accounts, my retirement accounts, any assets, any financial accounts, any property with my name titled on it, she will have the authority to do that. She will not have to pause, go talk to attorneys, see which ones she wants to hire, come up with $7,000-8,000 and spend 6 to 12 months in the court system. She will immediately hit the ground running with the powers of attorney. So I strongly recommend that all of you guys have a set of powers of attorney that are drafted by a Texas attorney and that are within the last 5 to 6 years of being drafted. The reason being the laws can change. And so we've kind of found that if our clients stay within 5 or 6 years of having new powers of attorney, normally things are going to go well. Okay. If on the other hand, this happens to me, my wife goes to the hospital, she's going to have a difficult time. She tries to sell her house. She's not going to be able to. She wants to access individual accounts with my name on them. She's not going to be able to. She wants to sell my car with my name on it. She's not going to be able to without going through the court system, becoming my legal guardian. So we strongly recommend powers of attorney. In Texas, the worst thing that you can do from a standpoint of leaving your family in a bad position after you pass away is to have no estate planning documents whatsoever. That's called intestate probate. It's very expensive, very time consuming. Your family's going to spend a lot of money. They're going to spend a lot of time in court, and they're going to be subjected to a very strict court formula as to who gets what. This is particularly a problem in blended families. So if you're a remarriage, if you're in a blended family, if you have stepkids, you really, 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 really need an estate plan that spells out who's in charge, who gets what. Because I had to do this 2 weeks ago. I feel like once a month, I have to tell somebody, it seems like usually it's the wife and the husband passes first, that's great that you and your husband have a house together. That's great that he left all his retirement behind. But because he didn't have a will or he didn't have a trust, you're now going to have to own a portion of those assets with his stepchildren or with his children, your stepchildren. Sometimes that's a good relationship. Sometimes it's a very bad one. So please keep in mind the worst thing you can do is to not have any sort of estate plan. The next best thing you can do is to have a last will and testament, very popular, well-known document. Just so you know, right out of the gate, a will sends you to court. A will does not help you avoid court. It will send you to court. It has to go through the court system so that the executor has the court authority to act under the will and to get, to sell the house, to access the bank accounts, to distribute them. However, it will send you to court in a cheaper, quicker, less draconian way than not having a will. Okay, you're going through the court system with a set of instructions. This is who's in charge. This is who gets what, and it is so much better than not having a will. However, like I said, there is a way in Texas to avoid the court system altogether, and the good old-fashioned way is to have a living revocable trust. That allows us to completely avoid court, period. Somebody passes away, their assets pass directly through the trust. You don't have to hire an attorney. You don't have to pay the money to go to court. You don't have to spend the time in court. You can also minimize conflict with family because you're not going through the court system. We're not contesting things. You can also oftentimes, to be honest, avoid creditors in that manner as well, which when you go through the court system, you cannot. Now, this will lead us to our next 2 or 3 planning mistakes. And keep in mind, these all have to do with having a living revocable trust. So everything we're going to talk about happens within a trust. So in addition to a trust helping us avoid probate court when somebody passes away, it can also help us do these other things here. It can help us with divorce protection, which I'll explain, creditor protection, lawsuit protection, beneficiary protection, and something we call remarriage protection. So kind of a quick synopsis of these. Divorce protection is for the benefit of your beneficiaries. So if I inherit $500,000 from my mom and I keep that separate from my marital estate, meaning I keep it in an account in my name, I don't commingle it in accounts in my spouse's name. If I end up in a divorce, I walk out of the marriage with every dime of that. If I commingle it, my spouse and I split it. The divorce courts will split it up. So we can have in trust language that enables and basically orders our beneficiaries to keep their assets separate upon inheriting them, so that if they end up in a divorce, they will leave the divorce with all of their inheritance. Okay. Lawsuit protection, protection for beneficiaries. So every beneficiary might be different, right? Let me give you a great example. A family a few years back that we helped set up an estate plan for, two daughters who were older, and then the baby of the family was the son. And when I say the baby of the family, he was 51 years old, and the other daughters were in their 50s, and my clients were in their 80s. The two daughters had done well in life. They had gotten married, they had kids, they stayed married, they had good careers. My client, each kid was going to inherit about $1 million when my clients passed, and he thought it was absolutely great and fine for his daughters to inherit their full amount. They could get their $1 million when he died. He had every faith in the world that they would spend it correctly and not waste it. His son, on the other hand, he had great concerns about. He was financially immature. Even though he was 51, he had a history of bad marriages and divorces. He had basically next to nothing, even though he was 51, because he'd been wiped out in divorces and bad decisions in life and poor money management. So my client, instead of just giving him his $1 million when he died, he set up his son so that he would get $50,000 a year every year after his dad passed. And so he basically set his son up with a retirement. He set his son up not to just blow all the money in a bad marriage, making poor decisions with investments or whatever this guy had going on in life that caused him to not be able to be financially mature. So with a trust, you can treat each beneficiary different and unique. You can set things up so that they don't waste or maybe even hurt themselves. Another client who had a son in his 40s who had a history of drug abuse, and he had been clean for 4 or 5 years, but they were really worried that if he suddenly inherited, $500,000-600,000 all at once, it would trigger him and he would relapse. So we can plan for a lot of things in a trust. We cannot do that with a will. We certainly cannot do that with nothing. So a trust is the only device that helps us to do these things like financial maturity. Now, to continue, planning mistake number 4, remarriage protection. This is kind of my favorite. This is my favorite story to tell anyways. I don't know why, it just is. But, and I'm going to throw us men under the bus, just so you guys know we're getting thrown under the bus here. But this is the situation where a couple comes in, they sit down with me, they say, look, we're 62, we've been married since we were 20, we have 2 kids, they're doing great, they're 40 and 42, and there's nothing funny going on here. Just, this would be really simple. When the first one of us passes, everything will go to the next spouse. When that spouse passes, it's all for our kids. Very simple. But I have to introduce the idea, what if, Mr. and Miss Smith, one of you pass away and the other one of you does what? Gets remarried, right? Those things do happen. And they both look at each other and kind of giggle and say, oh, we wouldn't do that. I would never do that. It's not going to happen. And then I have to inform them, well, it does happen. I see the aftermath of this in my office numerous times a year, where the following happens. And I will say this, 80% of the time, it is us men doing this. It is the husbands doing this. When we lose our wife first, particularly it seems like if we are men who have been in a long-term, one-time marriage, we tend to get remarried. We tend to get remarried fairly quickly. And it tends to make our adult kids very unhappy with us, which tends to cause a big argument in the family, which tends to cause the father to get upset and say, if you're not going to act right to her, if you're not going to respect me, I'm just going to go see Brandon and I'm just going to cut you out of the will, or I'm going to cut you out of the trust. And then they're in my office, the adult kids, completely distraught, beside themselves that their dad's acting this way. Well, if we paused and we go back in time real quick to when both spouses were alive and well, both spouses were able to make good decisions, this family could have chosen remarriage protection in a trust, which puts in a bunch of rules in the trust, which apply and govern the surviving spouse after the first spouse passes, which can go a long way in preventing fraud, waste, abuse of the estate, and basically the estate going to third parties, such as a new spouse or a new spouse's kids, and so that all the remainder after both spouses are gone can actually go to the kids in the way that the family intended, rather than getting diverted off in the direction of the new spouse's family. Okay, so you married ladies out there, you take note of this. If you pass before your husband, which is unlikely, but it does happen, he may not make good decisions after that happens. This is what we see for some reason. Planning mistake number 5, and this is still, we're talking about a trust here, is within a trust, we can have what's called retirement plan protection, protecting our retirement assets, our 401ks, our IRAs. And I'm not talking about protecting those assets while you're alive. That's really the job of your financial planner. I'm talking about after you pass away and making sure that we don't have financially immature beneficiaries. This is the stereotype of, and this, I know a lot of financial planners, and this happens to them all the time. The immature, whether the person's 35 or 40, 45, but the immature person who hasn't lived a very thrifty lifestyle shows up at the financial planner's doorstep the second they can and says, look, I've got this from the court, and I'm entitled to every dime of this, and I want it all now. And the financial planner says, wait a minute. If you withdraw all this money today, you're going to pay, 40% taxation on this. You're going to get kicked way up in the tax bracket. Why don't we take this out over a period of time? Right now, by law, it has to be 10 years. You have to get all the money out within 10 years. So why don't we take this out over 10 years, and you can, lower your tax bracket, and you'll save a lot of money. No, I want all of that right now, and I know I'm entitled to it. My attorney, Brandon McGee, told me that I am entitled to that. And here, look, we probated the will, so give it to me. We can set things up in a trust where your retirement dollars follow the pattern that you want. They don't all get distributed at once if you don't think that's a good idea, so that we can minimize the loss by taxation by forcing the beneficiary to be mature and to be thrifty in the way that they handle things. So keep that in mind too. Also, so that you guys know, the federal estate tax can also be avoided with the trust. I'll kind of throw that in here in this one, but we can avoid the federal estate tax when we have a trust. We do not have a state death tax in Texas, but we do have a federal estate tax, and all of our trusts have language in them to avoid that. Okay, planning mistake number 6. And by the way, there's just one more, so we're getting pretty close to the end here. This is the crowd, and you may be in this crowd, and if so, that's you're not a bad person. It just means you have not been informed yet. But this is the do-it-yourself crowd. This is the, I'm going to get on the internet. I can do all this myself. I don't need an attorney for this. Or I'm just going to get a copy of my brother in Arkansas had a will drafted 12 years ago. I'm just going to copy that, make my own will. The people who draft their own documents, I'm going to tell you right now, that is the cheapest way to do things. Just like the cheapest way for me to get my car fixed is to fix it myself. The cheapest way for me to fix the air conditioner in my house is to fix it myself. The cheapest way for me to get a knee operation is for me to operate on my knee myself. However, I can tell you on all accounts, that's a really bad idea. It's a horrible idea. And I think the same thing with people who draft their own estate plans. It's just a bad idea. The chances that the documents are not going to be right, or even if they are right, that they're not going to be executed and signed in the right manner is very, very high. And I've seen a lot of disasters as a result. So just trust me that it is worth spending a little bit of money up front to get things done the right way. Also, people who don't get timely updates, people who don't fund their trust if they have a trust. So you'll see the list here. These are all ways that people can really make some big mistakes, basically in either just not getting it done right the first time, or not keeping up with the updates, not getting it reviewed periodically. I offer for all of my clients, they are entitled every 2 years to a complimentary estate plan review. I will not charge them. They come in, or we can do it by Zoom, or we can do it by FaceTime, and we'll review their plan, and we'll review what's happened in their life the past 2 years. And plenty of times there's not anything that needs to be changed. Everything's in good shape. But there's also enough times that, there has been some changes in the family. There have been some changes in the assets, and we need to reflect those in the document. So if you really want to have a good estate plan, have it drafted by a legal professional in the state of Texas, and every couple of years or so, check in, and specifically when things happen that will affect your plan, go to the legal professional and have those addressed, okay? Real critical. Planning mistake number 7, last but not least, certainly not least, no legacy protection. Now, up until this point, a lot of what we've been talking about, either directly or indirectly, has been about money, right? Saving money from the nursing home, not having to go through the court system and spend money, protecting your retirement assets, yada, 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 et cetera, et cetera. However, in life, money, while it is important, right? We got to pay rent, we got to eat, vacations are nice, shopping here and there is nice. But there are a lot of things that are just as important, if not more important than money, such as the values that we leave behind, the behaviors, the examples of behaviors that we leave behind, the life lessons, the life stories that we have. So we think it's important to leave a personal legacy as well, not just a financial legacy. And so at our firm, we have a legacy workbook, which asks you a whole bunch of questions. And if you go through and you answer all those questions, by the time you get to the end of it, you'll have basically left a biography of your life. You'll have left, religious principles that are important to you. You'll have left those behind. Ethical principles, experiences, your educational background, your work background, your travels, your studies, things like that. So we think it's really critical to leave behind a strong legacy, which includes basically an autobiography of your life and the things that you think are important to pass down to the next generations. Now, let's just recap real quick a living trust and how it works. Number one, a trust is simply a legal document. And once you have it set up, we assist our clients in attaching or connecting, or what we call funding, your assets into the trust. So your assets have to be connected to the trust. And once that's the case, that's the magic of the trust. So what can a trust do for us? If I set up a trust and I put all my assets in there, I connect all my assets to that trust, what is it going to do for me? Well, all the things we just talked about. It is going to help us avoid probate court. It is going to help us avoid the estate tax. It is going to give us divorce protection. It is going to give us remarriage protection. It's going to help us avoid creditors potentially. And it's going to allow us to treat each of our beneficiaries different if circumstances call for that. We're not just going to cut everybody a $800,000 check and say good luck. We're going to set things up so that they pass in a very responsible manner that keeps in mind each individual. Also, I have a lot of clients who may end up leaving some amount of money to grandkids, and they may be young, and maybe they want that money to be spent on college, or maybe they want that money to go to them when they're 25 or when they're 30, but certainly not when they're 18. Those things can be accomplished using a trust, and that's the magic of a trust. No other estate planning document in Texas or in the US that I'm aware of can do that. It has to be a trust to accomplish those things. Real quickly here, we're getting very close to the end. With a trust, if you set one up, you're the trustor, meaning you own it. You're the trustee. If you're married, you're the trustees, meaning you manage it. And you're the beneficiaries, meaning while you're alive and well, it's all for your benefit. You maintain total control. I often get asked, what's the downside of a revocable trust? I see zero downside in a revocable trust, and I see a lot of upside. So when you have a revocable trust, you can buy things, you can refinance things, you can sell things out of the trust. Extremely flexible document, okay? Now funding, that's where we have to connect the assets to the trust. It's unbelievable to me how many clients have walked into my door with old trust who they are completely unfunded or only partially funded, meaning when the person, if they pass away, it's not gonna work because you have to connect the assets. So we take great care to have our clients, to help our clients connect their assets to the trust. And we actually have a specific meeting for that after the signing meeting where they sign off on their plan. We meet again. A lot of firms will stop at the signing and there you go, good luck, it's all done. We go a step further and make sure our clients have their plan funded appropriately. Now, I want you to think about something here real quick. We're at the end. And before you think about this, let me tell you that at our firm, we always offer a complimentary consultation for the first time to any individual or any family for up to an hour. So that consultation can be done in person. We wear masks, we have plexiglass on our conference table separating us. Or in this day and age in particular, we're happy to do the consultations. We've been doing a lot of Zoom, a lot of FaceTime, Some people just like say, hey, I'll just talk to you on the phone, and we do telephone consultations. But I want to let you guys know and encourage all of you to take advantage of that. If you have older and or out of state estate planning documents, I do I review hundreds of those a year. So I'm happy to review your old documents. If you do have out of state documents, that's a huge red flag. Okay. You need some kind of a new plan. If your spouse has passed and your old plan has your spouse all over it, it's a big red flag. If you are a blended family and you don't have an estate plan, big red flag. So I want to encourage all of you guys to take advantage of that. Up to an hour, it'll be on us, and we will not charge you. But I want you guys to think about this. It's a terrible scenario, although I just put myself through this scenario several times, talking about me suffering different calamities and what life would look like for my wife if I did. But for you guys, think about this. If tomorrow you or your spouse is, let's say, in a bad accident, and one of you is deceased, or one of you loses your mental capacity and has to go into a nursing home, what is life going to look like for you, or what is life going to look like for your adult children if they're the ones who are going to be in charge? Do you have all your criteria here that we've just gone through? Do you have everything laid out in a good manner? Do you have an up-to-date plan drafted by a Texas attorney that addresses all of these issues so that you're leaving a really smooth road for your family to travel down, or for you to travel down if you're the one that's going to be dealing with this? Or do you think you're leaving a pretty big mess behind? Are you going to be sending your family into a tailspin, running around town, hiring attorneys, trying to figure out what they're supposed to do, trying to figure out how are we going to pay for nursing home care, but let's just start cutting, $7,800 checks a month until we figure it out? That's what you don't want. People, when people pass away, as we all know this, I know this firsthand, when people pass away, when people have major medical scares, we're very emotional. We're already in an emotional whirlwind, usually, as is. We don't want to add to that by having to go through the legal system and meet with attorneys and go to court and pay exorbitant fees. So I want to encourage all of you guys, if the answer is that you are not going to leave your family in a good spot if something happens to you tomorrow, don't be like this gentleman here. Although he's dressed like me, that's not actually me, but don't be like this gentleman here with your head in the sand. We want you to take advantage of the complimentary consultation. So thank you guys for listening to me. Mitch is going to Mitch the hand is going to join me here, and I'm going to answer questions that you guys have. I'm also going to drink water because I just talked a whole lot.
All right. Well, fantastic. That was very informative. So I do have a question here from Christine Taylor in our chat, and she wanted to know, I apologize, I have a printer running next to me if you can hear that. If you put assets in a trust, what happens if you want to sell something?
Good question. If it's a revocable trust, revocable with a capital R, it's very simple. You just sell it as the trust. You sell the asset as the trustee. So, for example, if my house is in a trust, so let's say that I'm going to sell my house tomorrow. Instead of selling my house as Brandon McGee, I'm selling my house as Brandon McGee, trustee of the McGee Family Trust. So it's very simple. It's just a matter of selling the assets as the trustee as opposed to as an individual. With an irrevocable trust, those are a little bit more complicated. Those are the trusts that can help us qualify for Medicaid after 5 years. That you need to be more careful about before establishing one. There's different rules that surround those. Those are the kind of things that we'll bring people into the office or have a Zoom call and talk about their individual situation. But with the revocable trust, very easy, very flexible. Irrevocable can be a little bit different, so you want to be more careful about that.
Fantastic. Okay, does anyone else have any questions? I'm going to try and look for some waving hands, or if you know how to use the chat, you can type it into the chat. Diane Orr was asking that you provide your contact information again.
Yeah, definitely. So you can reach us, number one, on the web at McGeeLawDFW.com. You go to McGeeLawDFW.com. We have all of our contact info there. For my email is Brandon at McGeeLawDFW.com. So again, it's Brandon at McGeeLawDFW.com. And then the best phone number to reach us at, and this is probably the best way to reach out to us, to get a staff member that can immediately set an appointment for you. It's 817-899-3286. Again, it's 817-899-3286. And that's the best phone number to call us at.
And I put all that information in the chat for everyone. If you want to open that up, it is over there for you. Now, I do have more questions. Okay. So if you don't have family that wants to be involved in your last will and testament, can another person be appointed?
Absolutely, yes. It can be, even if your family wants to be involved and you don't want them to be involved, it's completely up to the person creating the will, creating the trust. So it can be anybody that you want to that's over the age of 18 and of sound mind. So oftentimes, though, I'll tell people, if you're not going to pick a beneficiary, such as a child, an adult child, or a spouse, you might want to leave a carrot at the end of the stick for that person. You might want to offer to pay them out of your estate in the document so that they feel motivated to do the job, because it can be time consuming, particularly if you're going to leave a will behind rather than a trust. That person's going to have to go hire an attorney. They're going to have to go through the court system. But even if it's a trust, they're going to have work to do. So you absolutely can pick anybody you want. There's also bank and trust companies out there. For example, if somebody feels like their beneficiaries may become high conflict after they die, or if they feel like that none of their adult children are suitable to do the job. I've had some clients ask me to do it. So from time to time, I'm probating a will or I'm administering a trust. And there's also bank and trust companies out there that have departments where they'll also serve those functions.
Wonderful. Okay. So Sally Zimmerman, and I think I'm understanding the question right. She said, so if you establish a trust in Texas and move to another state, do you start over your 5-year window to qualify for Medicaid?
Well, that's a really good question. And number one, let me say this. I didn't know the question was going to end with Medicaid. So the first thing that came to my mind was, anytime you move to another state, you need to consult with a legal practitioner in that state about your estate plan, period. And so for me, I'm a member of the American Academy. We have practitioners all over the country. So I have a network where, when I have clients move out of the area, where we can generally find somebody to refer them to. And then I have other Academy members referring folks to me who move into DFW and into Texas. But in general, you need to go to a practitioner in that new state and sit down and talk with them about every aspect of your estate plan. Normally, we don't have to throw the baby out with the bathwater. We normally don't just have to completely ditch the old plan and start over. A lot of times here in Texas, we'll do what are called amendments. And we'll update maybe the powers of attorney, get new ones, but do an amendment to the trust, an amendment to the will, putting it under Texas law. For Medicaid, I honestly don't know the answer to that, because the answer is it depends on the state. And so I can say in Texas, if somebody comes into Texas with an irrevocable trust, with the proper language that they've had in place for more than 5 years, they're going to be okay. They're not going to have to start over. Going to other states with the Texas product, it probably just depends on the state. So it's hard for me to say, and I would defer you to a practitioner in that state.
That makes sense. Okay, so next question. This one's technical, so put on your listening ears, Brandon. All
Okay.
right, we have a trust where my disabled adult son is on Medicare, Medicaid. Okay, his brother is in charge of a monthly distribution in order for him not to lose his benefits. So what happens if the brother doesn't give him his monthly payment?
Okay, so I'm going to assume this is probably what we call in our industry a special needs trust. That's what it sounds like. The purpose of a special needs trust is for somebody who is on SSDI, Medicaid, because they have a disability, that they can receive the amount of money that they're allowed by law rather than receiving the entire inheritance at once and getting kicked off Medicaid or SSDI. But more to answer the specific question, if under an estate planning document period, whether it's a special needs trust, a regular trust, a will, a power of attorney, if somebody's not doing what they're supposed to, another family member needs to step up and file a court action. Unfortunately, it would require somebody stepping up to the plate and saying, this sibling is not distributing the money. Maybe they're using it themselves. I mean, let's just be honest. Those things happen, unfortunately, and we see that not infrequently. Okay, and so a lot of times that we'll have somebody defrauding an estate, particularly if somebody's incapacitated. They think they're going to get away with it. There are criminal laws against that. People can end up in prison. There are felonies. People can have civil liability, criminal liability. So I would say that person needs. I mean, if somebody came to me and said, "Hey, this person's, not spending the money the way they're supposed to," and we think they're actually, they've got a new Corvette and suddenly they're going on vacations every other month, we think they're spending it on themselves, I would encourage them to file a lawsuit with the probate court, and I would encourage them maybe to call the economics crime unit of their local DA to investigate that. So a way around that usually can be to appoint two trustees. You can have two executors of a will. You can have two trustees under a trust. That way, the two people would have to collude to defraud the estate or to not do what they're supposed to, which is more unlikely. So you can have multiple people so that you have an extra pair of eyes on it. Or like I said, you can appoint, you can have a bank and trust company or a professional trustee.
Okay. So will a trust work if you leave money to family in another country?
Well, that gets more complicated, but generally speaking, yes. Now, let me say this first. We are in a very international area here. DFW is a big city with people from everywhere. And I have a lot of clients who are from other countries. And your assets that are in the other country, you absolutely need to talk to an estate planning practitioner in that country about those assets. I can't tell anybody that, if it's India, if it's England, if it's Canada, if it's France, I can't tell you that my estate planning product is going to work in that foreign country. However, your US-based assets, let's take India, for example. I have a lot of clients who are from India. And let's say that you have a US-based, you have financial accounts and property in the US, but one of your beneficiaries is in India or in any other country. Absolutely, it's not a problem to liquidate those assets and to transfer them to the person in that country. So that should not be an issue at all. However, if you have assets in a foreign country, using a US-based estate plan to address those is not a good idea. You need to talk to a practitioner in that country to see if that's okay or not.
All right, great. So we've got a couple more questions that have come through. And if anything comes up after this point, what I'm going to do is suggest that you reach directly out to McGee and Brandon so they can help you. And some of these are getting a little, okay, so do you serve the San Antonio area?
So yes, I can. Number one, I can serve clients anywhere in the state of Texas because all of our laws are going to be the same. And nowadays, especially, we've all become so accustomed to Zoom and FaceTime. I actually just this morning had a client who did a signing in College Station, Texas, and so we did it over Zoom. I'm able now, under our new state laws, to serve as a notary by video. on legal documents. So that's helped tremendously. So yes, I can, anybody who's in the state of Texas, whether it's Brownsville, Amarillo, El Paso, Texarkana, anywhere in between, we can absolutely serve them as a law firm.
Great to know. Okay, so can we change the deed title of the home now to a family member to start the 5-year qualifier for Medicaid? And then it says, then if my Social Security is already above the income cap, do you just focus on all other assets to give the Social Security check to Medicaid?
Okay, let me address the first one, then if you'll reread that second
Yep.
one. The first one, I don't recommend changing the title now to your family member. Certainly you can, but one big problem with that is the gift tax. So let's say that the land's worth $250,000. The gift tax limit is $15,000. What that means is that you're going to be paying about a 40% tax on $235,000. So whenever you start gifting to people, keep in mind everything over $15,000 is going to be hit. You're going to be hit with the gift tax, and particularly if it's real estate and it's hundreds of thousands of dollars, that could be a lot of money in tax money. So I don't recommend doing that. If it's your homestead, number one, I don't know if it is, but if it is the homestead, remember, if it's under 585, that's not going to be countable by Medicaid. If it's not your homestead, let's say it's a family farm, it's a condo at South Padre Island, it's a rental home, your better bet is to put it into the irrevocable Medicaid protection trust, and then pass it to that family member after you die. That way we can avoid the taxation issues. There would be no taxation issues. So I would recommend that over, depending on the amount of the value of the gift, I would generally recommend not gifting large amounts of money like that, because it's just not worth it to pay the taxes when there's other ways to pass things down after you die where we can completely avoid taxation altogether. And then what was the second question about?
So that's okay. I wasn't sure if they went together or not. I'm not an attorney.
Okay.
It says that if my Social Security is already above the income cap, do you just focus on all the other assets and give the Social Security check to Medicaid?
Yeah, that's pretty much right. If you're going to be on Medicaid, you just go ahead now and accept that your Social Security is actually not going to Medicaid. It's going to go to the nursing home. So your Medicaid is already lost. Your Social Security is already lost to the nursing home at the point in time that you are going to get on Medicaid. So we'll be talking more about the other forms of income that you have coming in. And by the way, that is everything. Sometimes people say, well, I make $800 a year off these mineral rights. It's not much. Well, you got to count that, right? Or I get this one-time annuity payment a year of $12,000 bucks. Well, we're going to have to count that. We're going to divide it by 12. But they count everything. Medicaid counts everything. All of your income, all of your spouse's income. Like I said, even if you were married a week ago, if you apply for Medicaid, they're gonna count everything. So keep that in mind as well, guys, when you plan.
Okay. All right. These will be my last 3 questions. Okay. If you have an equity loan, does that cause probate? They state they have a will and a power of attorney.
Okay, so I'm assuming they're talking about I'm assuming that they mean that they have a home where they took out an equity loan. I think that's what they mean. So if you have a home and it's subject to any liens, whether it's a lien from a mortgage company or just a judgment holder, you can't shake those off. Whether you go through the court system, whether the real estate passes through a trust, it doesn't matter. That those lien holders are gonna keep their liens, and the new owner is going to have to satisfy those obligations. So if I refi my house and I take out an equity loan and I owe Wells Fargo $120,000 and I pass away the next day and leave my house to my kids, they inherit my home subject to that lien, and there's no way around that, guys. So whatever debts exist against your real estate that are secured by a valid lien in the state of Texas, those will be inherited by the people who inherit your land, your real estate.
Okay. All right. If you make a living revocable, not irrevocable, revocable trust, do you also need a will along with separate powers of attorney?
Yes, absolutely. So with the trust, we prepare what's called, every single time I draft a trust, I also draft what are called pour over wills for each trustor. And the reason is, despite all our good intentions, you may set up a trust and you may fund all of your assets into the trust. 8 years later, you may open a new savings account and you may forget to attach it to the trust. And if you pass away and you haven't attached or connected that asset to the trust, you need the will so that you can go through the probate court, or your family can, without a big, expensive, crazy ordeal that takes 9 months. So yes, we always prepare. Everybody needs a will, period. I don't care what you've done with your estate plan. All of my clients always have a last will and testament, just in case there's that straggler asset that they failed to get into the trust. We always want that there. And then you always want powers of attorney, because keep in mind, number one, 3 of the powers of attorney address medical situations, which the trust has nothing to do with. And then the remainder of the powers of attorney can address assets that are connected. This is getting really kind of off into the weeds, but I'll just say it quickly. You can oftentimes connect your assets to the trust through a payable on death beneficiary designation. So if I have a 401k with Fidelity, rather than just retitling it into the name of the trust right away, I can do a payable on death beneficiary to the trust, which means that money would go into the trust when I die. But if I'm incapacitated, it's not in the trust because I'm still alive. And so the powers of attorney would be used in that circumstances. So to make a long story short, yes, please we have 7 that we provide our clients with. You always want a strong set of fairly up-to-date powers of attorney. Absolutely.
Awesome. Okay, so we're on to our last question. So as your assets change over time, must a living revocable trust be continually updated?
No, that's a great question. And I get asked that a lot. Frequently I'll get asked, so every time I buy a new house or I set up a new bank account, I need to come see you and you need to do something. And the answer is no. Now, I do encourage my clients to check in with us and to say, hey, we're entering this business venture, we're purchasing this property, we're adding this account, and we will not charge for that kind of a thing. And by the way, we're very good about this. When we have somebody who becomes our client, we take very good care of them. We don't charge them for conversations after the fact. I have people that call me, it seems like once a month, right, to check in on things, and we don't charge for that. But when you get new assets, I encourage my client to check in with us, just a quick phone call, and say, hey, am I doing the right thing here? Or what do I do? And we'll let you know. And then you just make sure that your assets attached to the trust. I don't have to amend the trust. You don't have to pay me to amend it. And then all of our clients also have a property schedule behind their trust. It reflects all the property they have. Just keep that up to date and mark out assets you've gotten rid of, write in the assets that you have. Our goal is simply that when somebody passes, the successor trustee, oftentimes, maybe it's an adult child, has a bullet point of all the assets that that the trustor had, so that we're not going on a wild goose chase looking for assets and we're not sure what's in the trust. So just keep good tabs on that in your trust folder and your trust binder. And you don't have to come back and pay us to do anything just because you bought a car or a house or added a new bank account. A good question.
Perfect. Perfect. Yeah, that was a great question. So I just want to let everyone know if they do have any other questions, you can go to McGeeLawDFW.com, and their contact information will be there. Otherwise, you can also find them on our website at celebrationmagazine.com. They are listed under our resources section, or you can call our office directly, and we can provide that information to you also. All right, so everyone out there in Facebook land, everyone in Zoom, my Zoom people, don't run away because we've got some fun questions and giveaways for you at the end of this presentation. But all of our Facebook people, thank you so much for joining us. If you'd like to join us in our Zooms, please visit celebrationmagazine.com and you can register there, and you too could have the opportunity to win fantastic gift cards as a thank you from our sponsors and from us here at Celebration Magazine. I'm going to unmute everyone. Going to try to unmute everyone. So that way we can give Brandon a big round of applause. He did a fantastic job. Thank you so much.
Thanks for listening.
Thank you.
Thank you. All right, goodbye, Facebook land. Everyone else hang out and we'll have a little bit more fun.